I'm Sally Ryder. I'm the director of the Rehnquist Center. I want to welcome you all here today. Thanks for coming. Thanks to all of our panelists and moderators for making the hard trip to Tucson in February. I want to introduce the associate director of the Rehnquist Center, Andy Cohen, who, right here, Andy was instrumental in putting this conference together, so thank you, Andy. I also want to thank Emily Caton and Bernadette Wilkinson, who are probably still out at the registration table, but they did all the logistics and everything to put this together, and it's a lot of work, and we could never do it without them, so thanks to them. It's hard to believe that Chief Justice Rehnquist has been gone for almost 10 years, and as we're here today to examine some of his legacy, I'm reminded of a poem he often quoted when he was asked to talk about cases the court had decided at the end of each term. Instead of the headline cases, he would often focus on the lesser-known cases, which he thought would have more impact in the long run or make a difference for practicing lawyers. And he would describe these cases by quoting from Elegy Written in a Country Churchyard by Thomas Gray. Full many a flower is born to blush unseen and waste its sweetness on the desert air. Appropriate for our setting here. Many in this room knew the Chief Justice, and so probably remember hearing him use that quote. I'm sure Chuck remembers that. There are several of the Chief's law clerks here, judges who worked with him. Our former dean, Tony Massaro, who will be here this afternoon, who welcomed him to the college for many years. The Chief came out here for about 11 years during February and taught a course, and people often say, oh yeah, did he come out and teach a course? No, he taught a course. He never did anything without doing it all. Tony was the moving force behind the creation of the Rehnquist Center, along with Mike Meehan, who is also here. Mike? So for anyone who knew the Chief, they'd also know that he would want us to get the show on the road. Our first panel is going to focus on federalism, a subject closely associated with Chief Justice Rehnquist. The moderator is Chuck Cooper, who clerked for the Chief and has been a generous supporter of the center. Mr. Cooper is a founding member and chairman of Cooper & Kirk, has been named one of the 10 best civil litigators in Washington, and there are no shortage of civil litigators in Washington, so that's quite an honor. So I'll turn it over to Mr. Cooper.
Well, thank you very much, Sally, and good morning, ladies and gentlemen. It's really a great privilege to be with you this morning here in Paradise in February. Any excuse to get out of Washington, D.C. is one I will take, but this one is especially welcome to reflect upon Chief Justice William Rehnquist's jurisprudence, to reflect upon my time with him before he was Chief Justice. He was just the boss. Many of the former Rehnquist clerks here in the room with us know what I mean by that. But Sally, when you mentioned this poem, you brought to my mind so many moments clerking for Chief Justice Rehnquist when he was Associate Justice, because one of the real blessings and privileges was how well educated you would become as his law clerk, not just in matters of law and constitutional law in particular, but in literary matters. He really was just extraordinary. And he would always have the apt quote for every occasion. His opinions, as I'm sure all of you here know, are sprinkled with those kinds of quotations. I remember one opinion when the perfect quote came from the Rubaiyat, the moving finger writes and having writ moves on, blah, blah, blah. He could he could quote it. He could quote the entire chapter 50. But I remember going in and saying, Mr. Justice, you know, not everybody is acquainted with this reference. Do you think we should drop a footnote to the Rubaiyat? And he recoiled. He recoiled and said, Chuck, that would be gauche. So he wasn't speaking to the people who wouldn't recognize that quote. It's fitting to open this conference on the jurisprudence of Chief Justice Rehnquist with an examination of federalism, because I don't believe there is any constitutional doctrine that meant more to Justice Rehnquist, certainly not in my experience, from where I sat. It meant more to him than federalism. And we're privileged today to have a very distinguished panel of scholars and genuine experts on constitutional law and federalism in particular to help us examine this subject matter, and about more I will speak in a moment. But my own education on federalism began at the boss's feet. And it was early on in my clerkship, as he was preparing for oral argument in what would be the second sitting in the October term in 1978. And it was his practice to grab a law clerk, whoever the clerk was assigned to a particular case, and go on a long walk around the Capitol neighborhoods there in the adjacent to the Supreme Court building. It was one of the real pleasures of clerking for Justice Rehnquist, was these long walks where you'd talk about the case at hand, but many other things as well. But that day we were talking about a particularly obscure labor law case called New York Telephone Company against the New York Department of Labor. Now, it involved an extended strike by the Communication Workers of America against the Bell System, which at that time was the monopoly, nationwide telephone monopoly. And it was a nationwide telephone strike involving something like 38,000 Communication Workers of America throughout the country. And that strike lasted for 1 week. Except in the state of New York, where the strike continued for 7 months. For 7 long months, the CWA workers of New York were out on strike. Now, how was it that the New York union members were willing to and were able to stay out on strike on collective bargaining issues that the rest of the country had managed to resolve in 1 week's time? How were they able to stay out and endure the economic burdens and sacrifices that a strike normally entails, and certainly entailed with respect at least to the rest of CWA workers throughout the country? Well, as it turned out, the New York union members really weren't making much of an economic sacrifice, at least nowhere near as much as their brothers and sisters throughout the rest of the country. And that's because they were allowed to draw unemployment benefits while they were out on strike from the New York Unemployment Office. And those unemployment benefits were quite generous, up to 1/2 of their normal salaries. And, you know, it seemed to me, anyway, as I looked at this case and prepared to discuss it with Justice Rehnquist, that really was pretty unfair, that one side in a labor dispute was being subsidized by the state to endure what ultimately is the ultimate labor law contest between labor and management. But what really worked me up about the case was that under New York's unemployment insurance law, the fund from which those striking workers were paid by the state, well, that fund actually was funded by the Bell System. The employer itself contributed the vast majority of the funds. And this is how Justice Powell described it in his dissenting opinion. During the strike, out of which the present controversy arose, the company's employees collected more than $49 million in unemployment compensation. All but a small fraction of these benefits were paid from the company's accounts in the New York Unemployment Insurance Fund. Because of these payments, the company's tax rates were increased in subsequent periods. So in New York, an employer was required to pay his workers to strike against him. And that didn't seem at all fair to me as the law clerk on the case. And it seemed to me that New York was placing a very heavy thumb on the scale in that strike and in that contest. between management and labor, and that's exactly what the National Labor Relations Act was designed to prevent, to make sure that those balances were in balance throughout the country. And so I thought the case for preemption under NLRA was pretty darn compelling there. I suspected Justice Rehnquist would think so too. And as we walked and talked about the case, I was frankly surprised when he opened the discussion by saying that as he read the briefs and he's read the statute and the legislative history, he thought the Second Circuit was due to be affirmed. And the Second Circuit had not preempted. They had upheld the New York State law. And so I questioned him. Did I hear you right on that, Mr. Justice? He said, yeah, the text of the statute really has nothing in it that would support or at least compel clearly preemption, and the legislative history seemed to tend against it, he thought. And we engaged in a little bit of a debate, as much of a debate as at that early stage of my clerkship I dared to engage him in. But he could tell I was kind of resistant to that theory. And this is what he told me, something along these lines. This is the best that I can recreate it from my memory. What he said to me was, the genius of federalism is that it accords the people of each state the freedom to decide for themselves. And the freedom to decide includes the freedom to be wrong. Now, I think this law is patently unfair. It's terrible policy. It puts an unjust thumb on the collective bargaining scale in favor of the union. And if I had been a legislator in New York, I would have voted against it, and I would have lobbied my fellow legislators to vote against it too. If I had been a voter in New York, I would have spoken out against it, and I would have attempted to elect legislators who would oppose it. If I were a Bell Company executive, I would consider moving my business to a state that would not force me to pay my workers to strike against me. And I have little doubt that the people of New York will pay a pretty heavy price for this wrong-headed policy in the fullness of time. But a majority of the legislators in the state of New York thought this was good policy. And they enacted that policy into their law. And those legislators were elected by the voters of that state. My position as a justice doesn't give me the power to impose my will on the people of the state of New York. Now, in this case, the Constitution, and here the Commerce Clause in particular, does give that power to Congress. But someone is going to have to show me that Congress has deliberately decided to exercise its power to impose its will on the people of New York. And they're going to have to show me that in some pretty clear terms. And so with that, we moved on to the next case. And so the most conservative member of the court in OT 78 broke with the other conservatives and joined Justice Stevens and the court's other liberals in affirming the Second Circuit by a 6-3 vote. Chief Justice Rehnquist, I'm quite sure, never gave another thought to that conversation. But I've thought about it countless times over the years, and I recount it here today because I believe that it provides important insight into Chief Justice Rehnquist's understanding of the nature of sovereignty and of freedom, because he didn't see a distinction between the two. He believed that sovereignty is the freedom of a people to govern themselves, to decide for themselves the rules by which they and their institutions are to live in accordance with their own interests, values, and beliefs as they see them. And the sovereignty of the people of New York entitled them to be wrong by his lights on that controversial issue of public policy, no less than it protected the people of his beloved Arizona to be right on some of those very same issues, according, again, to their lights. In other words, even with respect to those matters over which the Constitution delegates the ultimate power to Congress, the states were entitled to decide for themselves unless and until Congress clearly preempted them. And as to those matters on which Congress had no enumerated regulatory power, or it had exceeded that enumerated regulatory power, the states reserve the sovereign power expressly guaranteed by the 10th Amendment to decide for themselves, period, even despite what Congress may have preferred. So today we have, as I mentioned earlier, a very distinguished panel of scholars with us to help us further consider Chief Justice Rehnquist's jurisprudence in the area of federalism. Our first speaker today, and I'm going to just give a brief introduction of all of them, and then they will speak their piece, is Professor Lynn Berger. She's the Frederick M. Barron Chair in Law at the University of Texas at Austin, and she is the co-director of the Center on Lawyers, Civil Justice, and the Media. She holds undergraduate degrees from Yale and Oxford, and her law degree from Yale. Her area of specialty, she has several, but she is a leading academic defender of federalism and the rights of the states. Music to my own ears, I must say. But she's also one of the nation's leading scholars on issues of professional responsibility in group litigation, and she is frequently called upon to serve as an expert on issues of legal ethics, attorney's fees, and state and local government law. She's the author or co-author of really many, many scholarly works in the nation's leading law journals, but one of her most recent works, which seems particularly apt to our subject today, is The Spending Power After NFIB versus Sebelius, which I'm sure everyone will recognize as the Obamacare case. After Professor Berger will be Professor Eric Berger, who joined the faculty of the Nebraska College of Law in 2007. Received his undergraduate degree in history from Brown University and his law degree from the Columbia Law School, where he was the articles editor of the Columbia Law Review. After his law school, he clerked for Judge Merrick Garland in the D.C. Circuit, a very fine Court of Appeals judge and dear friend of mine who was clerking for Justice Brennan the term I clerked with Rehnquist. So your boss and I go way back. He's a dear, dear man. And practiced for many years with Jenner and Block. He teaches and writes primarily in the area of constitutional law. So it's a real pleasure to have Professor Berger here. Finally, Professor David Schwartz is the Foley and Lardner Professor of Law at the University of Wisconsin Law School. He holds bachelor's, master's, and law degrees from Yale University. He joined the University of Wisconsin Law faculty in 1999 after 12 years of law practice, where he specialized in employment discrimination and civil rights litigation. And for 3 years prior to the time he went into the teaching profession, he was working as a staff lawyer at this ACLU in Southern California. He also, after graduating from law school, clerked for Judge Betty Fletcher of the Court of Appeals for the Ninth Circuit. His scholarly interests and teaching focuses as well on constitutional law. So, again, we're very pleased to have all of you here and looking forward to your remarks. And we'll begin with Professor Berger. Thank you.
Thank you very much. It's a special pleasure for me to be here and to participate in this conference. One important biographical fact that was left out of that generous introduction is that I was a member of this law faculty for 5 years in the 1990s. And I met one of my former students here today. I can't believe we both aged. But I enjoyed every minute of every day of my time here. It was also during my time here that the justice first began. He first tried out the idea that he would teach a course. And he held his office hours in the office across from mine. And I felt somehow that my life's work was now more important because across the hall was the justice and his various federal marshals keeping the place secure. In any event, I want to take up today a fairly straightforward argument, which is that I believe that a major legacy of the Rehnquist court in the area of federalism was the revitalization of the National League of Cities type of doctrine and a belief in the very even-handed notion of dual sovereignty, all of which would require a robust 10th Amendment. I believe these views were the constant theme, the core compass, as it were, in Rehnquist's own federalism decisions, even before he became Chief Justice. And I think these themes continued with the support of a bare majority of the court during his time as Chief Justice. At the center of his personal federalism, I think, was an abiding belief in and commitment to the notion he expressed in National League of Cities of, quote, functions essential to the separate and independent existence of the states. He held firm to the idea that there were traditional aspects of state sovereignty, that there were integral governmental functions performed by the states that must be respected in order for the states to play their proper role within our federal system. He also, and more importantly, thought that the process of identifying these traditional aspects of state sovereignty was not only something that it was possible for the court to do, but was imperative for it to do within its constitutional role. Rehnquist wrote the majority opinion in National League of Cities in 1976, well before he became Chief Justice. It was a 5-4 decision. And that case, as you may recall, presented the question of whether some recent amendments to the Federal Fair Labor Standards Act minimum wage and maximum hour provisions, which extended those provisions to almost all employees of states and their political subdivisions, whether these amendments were within the power of Congress to enact. Rehnquist, writing for a majority of the court, found that Congress's powers under the Commerce Clause did not reach so far, and he stated that there are limits upon the power of Congress to override state sovereignty, even when exercising its otherwise plenary powers conferred by Article 1. En route to that holding, Rehnquist noted that Congress may not exercise power in a fashion that impairs the integrity of the states or their ability to function effectively within the federal system. He declared confidently that one undoubted attribute of state sovereignty was the state's power to determine the wages that would be paid to those whom they employ in order to carry out their governmental functions. And he was concerned to preserve these traditional aspects of state sovereignty because he thought that without doing so, he could not, the court could not, the nation could not have states that could effectively serve their role within this dual federalist regime. He was concerned about preserving a balance between the states and the federal government, and I think this is too often overlooked. He liked states, but he liked them in their place. And I'm going to talk in a few minutes about a case that was a bit surprising for how much of a nationalist he was prepared to be when he thought it was appropriate. Indeed, toward the end of the opinion in National League of Cities, Rehnquist took care to distinguish his states' rights holding in that case from the holding in Maryland against Schwartz regarding the Economic Stabilization Act of 1970, in which the court had held that the act was constitutional as applied because it temporarily froze the wages of state and local government employees. But this was a situation in which collective action by the national government was necessary to forestall more serious nationwide problems. He also noted that the Schwartz case differed from National League of Cities because the statute at issue in Schwartz displaced no state choices about how governmental operations should be structured at the state level, and it imposed no further burdens on the states that were unique to the states. 9 years later, in 1985, this is a year before he becomes Chief Justice, in Garcia against San Antonio Metropolitan Transit Authority, a slim majority of the court overruled Rehnquist's decision in National League of Cities. I believe that decision in Garcia haunted him. I believe it haunted him and his Federalist jurisprudence for the rest of his life, for the rest of his time on the court, And I believe that decision in Garcia ultimately set the agenda for much of what the Rehnquist Court's federalism jurisprudence became. In overruling Ussery, a National League of Cities against Ussery, the Garcia majority contended that Ussery's core notion, that is to say the Chief's core notion, of traditional governmental functions performed by the states was unworkable for purposes of drawing constitutional lines. The Garcia court explicitly rejected as, quote, unsound in principle and unworkable in practice, Justice Rehnquist's handiwork. It declared unsound in principle and unworkable in practice a rule of state immunity from federal regulation that would turn on a judicial determination of what counts as an integral or traditional governmental function. The court in Garcia went on to proclaim that this was not a problem for the states, that their integrity would be protected by the structure of the federal government, and so there was really no role for the court to play. Indeed, to have the court play a role would be problematic because we would now have unelected judges substituting their views for the views of the states, supposedly. The court stated this in the most aggressive possible terms. It explicitly overruled Justice Rehnquist's opinion. Not surprisingly, there were powerful dissents, and Rehnquist joined the very powerful dissents of Powell and O'Connor. He also wrote his own brief dissent of one paragraph, signed by him alone, from which I take my notion of how much this decision troubled him. In that dissent, he stated that the principle of, quote, fundamental aspects of state sovereignty that are essential to the state's separate and independent existence was, quote, a principle that will, I am confident, in time command the support of a majority of this court again. The next year, Rehnquist became Chief Justice. And although his court never explicitly overruled Garcia, it never explicitly returned to a National League of Cities doctrine, I think it's very clear that in practice it did. And I'm going to, in my brief time remaining today, just talk about 3 examples, 2 of them quite briefly. The first of the brief examples is Lopez. In Lopez, Rehnquist, writing for a bare majority of the court, observed as part of the parade of horribles that if the arguments, the horribles that would occur if the government's arguments in that case were adopted, and the court did not adopt the government's arguments, that the decision in Lopez, if it went the other way, would enable Congress to regulate in areas such as family law or criminal law enforcement or education, in which the states historically have been sovereign. And I think his choice of words was no accident. In Morrison in 2000, Rehnquist again, my second example, writing for a majority of the court, said, the Constitution requires a distinction between what is truly national and what is truly local. The regulation and punishment of intrastate violence that is not directed at the instrumentalities, channels, or goods involved in interstate commerce has always been the province of the states. Indeed, he wrote for the court, we can think of no better example of the police power, which the founders denied the national government and reposed in the states, than the suppression of violent crime and vindication of its victims. Now, those 2 cases, my guess is most folks in this room have heard about. But my third example, which I think is in many respects my most interesting one, follows Sally's notion of the little case that no one much cared about at the time. And this is the case, 2003 decision in Pierce County against Guillen. Guillen involved various constitutional challenges to a federal statute that attached certain conditions to the state's receipt of federal highway money. In particular, the regulations protected from discovery and introduction into evidence certain accident reports and highway safety data compiled and held by city and county governments. Everyone's already yawning. All right, we can see this is not guns in school zones. This is not violence against women. This is traffic data. The statute became the focus of litigation when the families of 2 Washington state motorists involved in traffic accidents requested accident reports and other materials and data held by county agencies related to the traffic history of the sites at which their accidents had occurred. The family members sought the information in order to pursue tort claims that the relevant local governments negligently maintained and operated the intersections at which those accidents occurred. Pierce County refused to provide the requested information, invoking the federal statute that they read to prohibit them, as a condition of the receipt of that federal highway money, from providing that information. They believed that statute rendered the information privileged, even for purposes of a state court proceeding. The Washington State Supreme Court ultimately held that the federal statute exceeded Congress's powers under the Commerce Clause and the Spending Clause. And as someone who had been fascinated by the Spending Clause, I could not have been more excited. This was the first case in which any court had struck down a federal statute as exceeding Congress's spending power under the doctrine set down in South Dakota against Dole by the court in 1987. That decision also was authored by Justice Rehnquist. Guillen seemed to offer the Rehnquist court, at least the states' rights 5, as I fondly called them, a rare opportunity to affirm that the spending power did not provide Congress an eternally available means of circumventing the restrictions in cases like Lopez that were becoming known as attaching to Congress's Article I powers. That is to say, a limited congressional power to regulate would mean nothing if all Congress had to do was attach a new condition to some federal grant of money to the states. I was excited. I thought for sure the court was going to take this up. It was a rare opportunity to revisit the spending power. But to get to that, the court had to find that this wasn't okay under the commerce power. It seemed clear to me that the court could find that this conditional federal spending was unconstitutional under Lopez and Morrison, because the statute arguably regulated non-commercial activity, the discovery and introduction into evidence of statistics and civil litigation. It arguably interfered with state judicial processes, which are surely a traditional core of state sovereignty. The court, however, didn't see it that way. I'm embarrassed, not really, to say that a colleague and I even submitted an amicus brief in the case. We were so excited. We mapped out for the court how it could now revisit the spending power, really make progress there. The decision was unanimous. They didn't even cite us, which for an academic is the worst. You don't mind if they don't do what you say, but they should at least give you a footnote. We got zilch. We got absolutely nothing. Justice Thomas authored the very brief opinion, which concluded that the statute at issue was in fact valid under the commerce power. Although the statutory provision at issue certainly regulated state court rules of evidence, it did so only with regard to evidence related to highway safety. And highways, of course, have always been subject to federal regulation under the commerce power. They have never been a traditional area of state concern. This little-known case, Guillen, which hopefully has moved up a notch in its fame as a result of my remarks today, is a clear example of the Rehnquist court's notion of dual sovereignty at work. The court fundamentally saw a case about highways, a traditional area of federal concern, and it gave the federal government its due. It did so, I might add, even when presented the rare opportunity, rare until the recent Disabilities case, to examine the increasingly important spending power. And I think it's very clear that there was ample opportunity within the ambiguous facts of that Guillen case for the court to have reached that matter. That the court didn't, although it was initially quite depressing to me, on reflection, which this conference has allowed me to engage in, I began to actually hold the court in higher esteem for having viewed the case as it did, as fundamentally about highways, having foregone that potential strategic opportunity to make progress in an area of great importance to 5 of them, and to hand down a decision that, in a very even-handed sense of dual sovereignty, very much respected the power of the federal government. Thank you.
Professor Berger.
Thank you very much. Thank you to Emily and Bernadette for organizing, and for Andy for putting the conference together, and to Chuck for the warm introduction. I guess I should start by saying I feel like a little bit of an imposter here, because my esteemed co-panelists are all federalism experts, and my work doesn't exactly focus on federalism. But a lot of my work focuses on what I call stealth constitutional decision-making, which is unstated or underdeveloped factors that can really help shape constitutional outcomes or constitutional norms. And I think this is a phenomenon that occurs in many different cases across the constitutional spectrum, but some of the examples are from federalism cases. So I want to focus on what I might call some of the stealthier aspects of what has been called the Rehnquist federalism revolution. And just to be clear, I'm using the word stealthy in a sort of very particular way. First, ways in which the Rehnquist court helped limit federal power and protect state prerogatives in ways that may garner less attention than some of the high-profile Commerce Clause or 10th Amendment or spending power decisions. And second, moves that are somewhat under-theorized and yet recurring cases, so it's unclear exactly what their precedential value is. And just to be clear at the outset, I'm not really taking a stand on whether this is a good or a bad thing. I don't mean it exactly in a pejorative way. I think in a sense, you could criticize it as the court kind of making these moves without fully explaining it, but in a sense, I think you can also see the court protecting its prerogative to go where it thinks it needs to go. To be clear, there are a lot of the Rehnquist federalism cases, as my co-panelists are discussing, that were hardly stealthy at all. And even the cases I'm talking about, I think the court is explicit that federalism is a very important value. And certainly Chief Justice Rehnquist was very explicit in a lot of his decisions as to the importance of that value. But I think sometimes in the service of that value, the court made some important stealthier moves that advanced the cause of federalism in somewhat interesting ways. So I want to focus on some of those today, and I'll also briefly allude to some more contemporary issues to see what insights we might glean from them. So the first area I'll talk about is federalism through statutory interpretation. Again, we tend to think of federalism values being enforced through decisions striking down congressional actions as exceeding the commerce power or the spending power or as violating the 10th Amendment. But federalism values can also shape statutory interpretation. And perhaps the paradigmatic case from the Rehnquist court was Gregory V Ashcroft. Brief background in that case: the Age Discrimination in Employment Act, the ADEA, said it's a prima facie violation for an employer covered by the act to specify a mandatory retirement age for employees over the age of 40. Missouri had mandatory retirement for its state judges, and in this case, the Missouri judges who didn't want to retire sued and argued that this mandatory retirement age violated the ADEA. So the question is whether the ADEA exempts state judges, thereby permitting Missouri and other states to set a mandatory retirement age. The statutory language of the ADEA exempts elected officials and appointees on the policymaking level. So Missouri in this case made two plausible, if contestable, textual arguments. It argued first that judges are subject to retention elections and therefore are elected officials. And second, it argued that even if judges are not elected officials, they're appointees on the policymaking level. But instead of trying to resolve the case on textual grounds, Justice O'Connor, writing for the majority, including Chief Justice Rehnquist, fashioned a super strong, clear statement rule. She wrote, "We will not read the ADEA to cover state judges unless Congress has made clear that judges are included." So the court shifted the burden to say that if Congress is going to intrude on state functions, it must do so with great clarity. And this reminds me a little bit of the labor case that Chuck started the morning off talking about. And I think from a federalism perspective, one can certainly understand why the court wanted to protect state government from federal intrusion on a sensitive matter like this. And I think that also calls to mind the Garcia case that Professor Baker mentioned. But as a matter of statutory interpretation, the court created quite a controversial canon. As scholars like Bill Eskridge and Phil Fricke have argued, the court turned what really had just been a presumption into a super strong, clear statement rule. And I'll point out that that move is hardly anomalous to Gregory. The court made a similar move in the state sovereign immunity area, where it said in Atascadero that Congress may abrogate state sovereign immunity only by making its intention unmistakably clear in the language of the statute. So these decisions protect states against federal intrusions, but again, rather than invalidating congressional action, they limit the reach of federal statutes via statutory interpretation. And I guess I would contend this is stealthy in a few ways. One, it's stealthy in that it's helping develop a robust federalism without making a high-profile constitutional ruling. Interestingly, the New York Times didn't actually even report on the Gregory decision when it came down. So statutory rulings sometimes get less attention than constitutional ones. Not always, but sometimes. Second, the court's also stealthy in that this canon is pretty manipulable. It's a bit similar to the canon of constitutional avoidance, which can be formulated in numerous different ways. So by allowing a constitutional norm to create variations of canons of interpretation, the court renders statutory interpretation somewhat less predictable. And the third argument is that I think you can contend that this is also sort of a bait and switch on Congress. So for instance, in the state sovereign immunity area, it likely thought it had abrogated state sovereign immunity in some instances, only to be told subsequently by the court that it had not done so clearly enough. Now that obviously wouldn't apply to congressional abrogations that occurred after the court had announced that rule, but it does apply to ones that occurred before. None of this is to take a stand on the outcomes of these cases or the underlying federalism values, but the point is to emphasize that the court can enforce federalism through aggressive but controversial statutory interpretation. And to discuss these moves very briefly in conjunction with more recent events, the pending case in King v. Burwell obviously presents the court with another opportunity to rein in federal power, not through a constitutional ruling, but a statutory ruling. You're probably all familiar with the case. That case asks whether the Affordable Care Act authorizes federal tax credit subsidies for health insurance coverage that is purchased through an exchange established by the federal government. The government argues that the structure of the act makes clear that Congress intended the subsidies to be available for health insurance purchased through an exchange established by either state governments or the federal government. But the challengers point out that the most relevant provision of the statute regards subsidies only, refers only to subsidies set up by exchanges established by the state. Now, obviously, the interpretive question posed in King are quite different than those in Gregory and Atascadero. King, in particular, pits a sort of literal textualism against a more contextual structural approach. And there's also a Chevron question in King of whether the agency's interpretation deserves deference. But King, nevertheless, is an example of another case that could substantially constrain federal power, not through constitutional ruling, but statutory interpretation. Second area, sort of broad area I want to mention is federalism through judicial review of congressional fact-finding. And one area that this arose a lot during the Rehnquist court was cases involving Congress's power to abrogate states' sovereign immunity under Section 5 of the 14th Amendment. I've already mentioned that to do this, Congress must do so clearly. And to just briefly summarize the doctrine, Congress has authority to abrogate, that is, to strip state sovereign immunity under Section 5 of the 14th Amendment. Under Chief Justice Rehnquist's opinion in Seminole Tribe v. Florida, Congress may not abrogate that 11th Amendment immunity pursuant to its Commerce Clause power. So whether Congress has properly abrogated state sovereign immunity in a given statutory scheme hinges on whether it's properly exercised its Section 5 power. Under City of Bernie v. Flores, the inquiry is whether the legislation is congruent and proportional to the targeted violation Congress sought to remedy. And given the nature of this inquiry, the court often looks to Congress's factual record supporting the legislation to determine whether a particular abrogation is congruent and proportional. But what's striking is the court's consideration of congressional fact-finding is quite under-theorized. So, for example, and in ways that can cut both ways. So, for example, in Board of Trustees v. Garrett, the court invalidated provisions of the American Disabilities Act, the ADA, in an opinion by Chief Justice Rehnquist. That statute authorized state employers to recover money damages from their state employees to recover money damages from their state employers for violations of the Act. Congress had made extensive findings regarding the pervasiveness of discrimination against individuals, but the court struck down the abrogation and it rejected the relevance of those findings, arguing that Congress had not found enough evidence of state discrimination. I think there's arguments that Congress actually had found a good amount of that evidence, and of course the statute had been passed before Bernie, so that Congress didn't know that the court would require such specific determination. So once again, we see the court limiting federal power in a somewhat stealthy way by saying Congress didn't do a good enough job gathering evidence, and that also gives the court quite a bit of flexibility to shape decisions by making these sort of under-theorized judgment about congressional factual findings. There are similar cases in that area in which the court, engaging in a Bernie inquiry, invalidated legislation purporting to abrogate state sovereign immunity because of at least in part because the findings had been inadequate. So we think of cases like Florida Prepaid and Kimmel. And most of these cases would fit within the traditional narrative of the Rehnquist federalism revolution. But sort of along the lines that Professor Baker was talking about earlier, there's also an important decision in which Chief Justice Rehnquist swung the other way in an abrogation case, and that example would be Nevada Department of Resources v. Hibbs, where the court upheld the Family Medical Leave Act's abrogation of state sovereign immunity. The court there highlighted the importance of congressional findings justifying prophylactic Section 5 legislation. So whereas the court faulted Congress in Garrett for failing to identify instances of state discrimination against the disabled, Hibbs credited Congress's findings in the FLMLA, even though in that case it was often mostly from the private sector. In fact, Dean Robert Post has argued that the congressional record supporting the FMLA was far weaker than the record in Garrett. Of course, there are other factors that can explain the difference between the outcome in Garrett and the outcome in Hibbs. Most notably, whereas the FMLA addressed sex discrimination, which triggers intermediate scrutiny under the Constitution, the ADA addressed disability discrimination, which only triggers rational basis. So given that it's easier to assert a sex discrimination claim, legislation passed pursuant to this remedy, passed to remedy such discrimination is more likely to be congruent and proportional. And I think that helps us understand the way the case is cut. However, while these distinctions might account for the different outcomes in the case, I think they don't fully explain the court's inconsistent consideration of congressional findings. And I'll point out that that inconsistent approach to congressional findings, or under-theorized approach to congressional findings, is still very much relevant today. Just to mention briefly two recent cases in Shelby County v. Holder, court refused to credit congressional findings of voter discrimination and striking down the coverage formula of the Voting Rights Act. Court certainly had a fair point that Congress had not updated the coverage formula in a long time, but it didn't really explain why it shouldn't defer to Congress's finding that preclearance was still necessary in those jurisdictions. And then a case on the other end of the political spectrum in Windsor, the court struck down the Defense of Marriage Act, looked at the congressional findings, and said there was animus here. Perhaps there's a good argument that there was animus, but again, the court didn't really explain based on the record how it found animus and why it didn't, why more deference wasn't due to Congress's findings. I think some major caveats are important. One, it's important not to overstate the case. Federalism values didn't always win in the Rehnquist court era. I think Chief Justice Rehnquist was trying to strike that balance. Also, I should point out, as I said before, that the court was often very straightforward about the importance of federalism values to its decision-making. So the point wasn't that the point is not that these decisions are stealthy and that they tried to sneak federalism values into a decision without admitting what it was doing, but that they are stealthy and that the court is enforcing federalism values through mechanisms that give the court a lot of leeway in future cases and that often fly under the radar screen of national attention. It's also important to mention that the Rehnquist court is hardly alone in using these sort of stealthy mechanisms. Other courts do so as well, but these decisions are good examples of it. I think a sort of final interesting takeaway here is that in a lot of these moves, the court is sort of aggressively protecting its prerogative to interpret both the law and the facts. You know, again, I think the Rehnquist court tended to favor positions that limited federal power and protected the states. So in the abrogation context, there are more cases like Garrett than Hibbs. But it's striking that whatever the substantive outcome, the Rehnquist court very aggressively insisted on its prerogative to decide the facts of law. So the court was very protective of the judiciary as an institution. And I think that's a phenomenon that we can see the court today very much continuing in the same vein that Chief Justice Rehnquist continued. So, thank you.
Professor Schwartz.
Thank you. It's really an honor to be speaking to the Rehnquist Center on Federalism because I understand that there are many of Justice Rehnquist clerks in the audience, and so I'm talking about federalism to people who had a hands-on role in shaping what I think are very major changes to federalism doctrine. There's no question that the Rehnquist court had a huge impact on federalism doctrine and changed it. And you could ask the question, did the Rehnquist court and Chief Justice Rehnquist make federalism better? Maybe. Federalism doctrine, that is. And I would say maybe. Did the Rehnquist court and Chief Justice Rehnquist make federalism doctrine more interesting? Lord, yes. As a citizen and a voter and a former ACLU lawyer, I'd be happy to have a spirited debate with you about case outcomes. But as a constitutional law teacher, I have to say, thank you. Thank you. You've made my life a lot more interesting because federalism doctrine was pretty boring before the Rehnquist court. So what happens is that in 1995, the Lopez decision strikes down an act of Congress under the Commerce Clause for the first time in 50 years. And that makes people sit up and take notice. And suddenly we're looking back, where did this come from? And so a lot of people who talk about the federalism revival or the federalism revolution or counter-revolution, depending on your point of view, would look at Gregory v. Ashcroft and New York v. United States, two opinions by Justice O'Connor, as the antecedents or the starting point. But I'm going to agree with Lynn Baker and go back to 1976 and National League of Cities v. Ussery, where we have the first time in 40 years that an act of Congress is struck down under the 10th Amendment. So in National League of Cities, we have this idea, and the court, you know, in a Justice Rehnquist opinion, is reaching for this idea that there is something in the 10th Amendment. We haven't entirely abandoned it like it seemed in the New Deal cases. It's not going to be as broad as it was in Hammer versus Dagenhart, and this idea that there are going to be a huge reserve of whole areas of regulation that are left to the states. That's abandoned, but there still has to be some core of sovereignty that states have that's going to revolve around state governmental functions, and the court was clearly reaching for that in National League of Cities. And then, as Lynn pointed out, 10 years later, that gets reversed in Garcia. And Justice Rehnquist issues this very evocative dissent that almost promises or threatens, depending on your point of view, that there would be yet another reversal. We had Schwartz, we had that more or less overruled in National League of Cities. We have Garcia overruling National League of Cities. So we have the court shifting directions 3 times in the course of 20 years, kind of unseemly for an institutionalist. And then this threat or promise that a reversal might occur again. And here I'm going to disagree with Lynn and say that I don't think that Garcia was overruled. And this, I think, is an important theme for me for the Rehnquist court, federalism, because by the time the next 10th Amendment issue comes up, Justice Rehnquist has become Chief Justice Rehnquist. He's no longer the lone dissenter of his early days on the court. He's now a leader of the court as an institution, and I see evidence of him taking a more institutional and I would say statesman-like perspective on federalism issues, so focusing on the 10th Amendment. When the 10th Amendment gets revived again in New York versus United States and later Prince versus United States with the anti-commandeering doctrine, it's a much more limited idea than what was experimented with in National League of Cities versus Ussery. We don't have the idea anymore that Congress can't regulate core state functions. Now the idea is more narrowly focused, that Congress cannot command state legislatures or state executives to carry out federal programs. An idea that has a lot of sense, but is also much more narrowly and specifically confined. And where the court has, I think, the clearest opportunity to reverse itself yet again, to overrule National League of to overrule Garcia, is in 2000, a case that isn't maybe as famous or well known as the Prince case, which overruled parts of the Brady Handgun Control Act. It's Reno versus Condon, a case involving the Federal Driver Privacy Protection Act. And the state of South Carolina said, well, gee, this is commandeering because we have to, in order to comply with a federal law that regulates not only us but also regulates private actors in terms of reselling private data. In this case, that was obtained through the state DMVs. South Carolina argued, to comply with this, we have to exert a lot of effort. Our executive officials are commandeered because they have to spend time and energy and essentially state budgetary money complying with this federal law. And isn't that commandeering? And the court was unanimous in saying no, in an opinion by Chief Justice Rehnquist, in which he reaffirmed Garcia and the idea that state governments can be regulated by generally applicable laws. And this might have departed from perhaps the federalism doctrine of his heart and the federalism doctrine of his early days as the lone dissenter. But as a Chief Justice, I see him looking more at the institutional issue of stare decisis, that the court can't keep reversing itself and changing directions. And there's almost a Holmesian quality to this, the idea that the path of the law is experience. And so sometimes the purity of doctrine has to give way to experience and to the kinds of settled expectations that build around a precedent. And so I think this is an act of judicial statesmanship. Now, one of the reasons why it's a little bit intimidating to talk to a lot of former Rehnquist clerks, is that you all have an insider's perspective. You know, to me, the boss is Bruce Springsteen. You have an insider's perspective that, you know, when I look, I can only look at the opinions and try to make inferences based on that. And sometimes, you know, I want to speculate or guess about what went on. How did this decision get made? And I'm very curious to know, for example, in Reno versus Condon, which was a unanimous decision, did all the justices agree, yeah, this is a no-brainer? Or did there have to be some kind of leadership there? Did the Chief Justice tell someone like Justice Thomas, you know, you can't go off the deep end here. We have a precedent, like it or not, that's been in place for over 15 years, and this is the way the law has to go. Another example of a kind of an insider story that I'm extremely curious about, and I would love to hear about this in the discussion that we have that we'll have momentarily, to the extent that you can talk about this without divulging Chambers' confidences. And that involves the case of Gonzalez versus Rage. Because in that case, we had a federalism challenge to the Controlled Substances Act, and the states' rights argument was that, you know, we're not talking about interstate commerce here. We're talking about somebody growing homegrown marijuana that they're using for medicinal purposes lawfully under state law. So we have a state policy choice that's in conflict perhaps with an extremely broad application of federal drug laws. And the question is, does the federal drug law apply this far to homegrown marijuana that's not part of the interstate black market in illegal drugs? And the interesting thing that happens here is that the nationalist point of view wins out. The Controlled Substances Act is given its broadest scope. It preempts this state law. And it was the four nationalist or liberal judges voting for the nationalist point of view, the preemptive effect of state law, joined by Justice Kennedy and Justice Scalia, who seemed to be switching sides from the positions that they took in United States versus Lopez and United States versus Morrison, where the court struck down acts of Congress as exceeding the commerce power. Well, the interesting thing there, of course, is that we have three dissenters. Thomas, O'Connor, and Chief Justice Rehnquist say that the Commerce Clause should not overrule the state policy choice on this particular area because it's pushing commerce too far. A very principled decision. And, you know, we can speculate, and I have in front of my students, Justices Kennedy and Scalia were more interested in the outcome. They liked the Controlled Substances Act. They're not crazy about the policy of medical marijuana, so they decided to vote on the nationalist interpretation there. The question that, of course, I'm very curious at and would speculate about is, had Kennedy and O'Connor joined the three dissenters, would 5 justices really have voted to say that medical marijuana was legal as a constitutional matter in states like California that had decided to legalize it? An interesting question that, you know, I can only speculate about. On the Commerce Clause questions, it's worth noting that although it was dramatic, the Lopez and Morrison decisions were dramatic, eye-catching, and led to, you know, a lot of academic commentary on this. This federalism revolution. We had this major dramatic change, but we have to put it into perspective and see how limited it was. And this, too, I think, is an example of judicial statesmanship and principle on the part of Chief Justice Rehnquist, whose opinions, while they did strike down these laws and he did revive to a certain extent a judicial role in policing the boundaries of federalism under the Commerce Clause, he did not try to roll back the clock to 1936. He very expressly embraced what we might call the New Deal settlement, the cases decided by the post-1937 court, Darby versus United States, and Wickard versus Filburn in particular, and accepted those as part of the constitutional landscape. And the principles I see here are not only Holmesian, the idea that experience, too much has happened since 1937 to go back to 1936. But also, I think this goes back to Chuck's remarks at the beginning, because I think another principle here is that whatever Chief Justice Rehnquist's interests in federalism and state sovereignty were, he also, I think, was a principled believer in the idea that, certainly on economic matters, that the policy choices of legislatures have to be given deference by the courts. And that's something that I think is a sub-theme that kind of runs below the headlines of striking down an act of Congress. I think those cases, Lopez and Morrison, are still consistent with that fundamental principle of judicial deference and not going back to 1936 judicial overreach, something that Justice Thomas, for example, has flirted with in some of his separate opinions in the recent era. So I would say that if we were going to evaluate Chief Justice Rehnquist on federalism issues, he gets an A on the 10th Amendment for principle and statesmanship. He gets an A on the Commerce Clause, maybe an A minus, because I have to let my personal views come in there a little bit on Commerce Clause issue. And then the third area that I want to talk about is preemption. And I'd like, if I may, I have 2 PowerPoint slides to show you. And this is an area of federalism doctrine that I think nobody gets a good grade on throughout the Supreme Court. And one of the issues here is that preemption, because it's a statutory interpretation area, it was only really in the last 10 or 15 years that it was even recognized as a federalism issue. And here's a statement of it by Justice Breyer in a case called Egelhoffer versus Egelhoffer, a kind of obscure ERISA preemption case. But what he says is this: the true test of federalist principle may lie not in the occasional effort to trim Congress's commerce power at its edges. That's kind of a side reference to the Lopez decision. Or to protect the state treasury from a private damage action, referring to the 11th Amendment cases that Eric was discussing. But rather in those many statutory cases where courts interpret the massive technical detail that is the ordinary diet of the law. In other words, when you have a preemption decision, if a state law is preempted, then that state autonomy takes a hit because the state law is nullified, not by holding up a clause of the Constitution, but by a statute, interpreting a federal statute. It basically nullifies state policy choices, and it seems that an important value of federalism, as stated in a case like Gregory V Ashcroft, is the ability of states to enact policies that differ from other states and from the federal government, a point that Chuck made earlier. And so here's where the record of the Rehnquist court on federalism becomes somewhat more muddy or murky, and it's on preemption cases. And what this chart shows, this is based on cases in the first 12 years of the so-called federalism revival. I started it with 1991 with the Gregory V Ashcroft case. What this does is it looks at the percentage of times in preemption cases that a justice voted to preempt a state law and basically to nullify a state policy choice. And the interesting thing that I found was that the so-called Federalism 5 voted to preempt in a much higher percentage of the time than the supposedly nationalist 4. Topping the charts is Justice Scalia, who votes to preempt about 80% of the time, in marked contrast with Justice Stevens, who voted to preempt something like 20% of the time. The other thing about this chart is the 2 bars show different kinds of cases. Sometimes a preemption case, such as an ERISA preemption typically, has a deregulatory impact, that the federal law is basically no regulation, and the state law is more regulatory in nature. And in those cases, the Federalism 5 were slightly more likely to vote to preempt than otherwise, the one exception being the Chief Justice. In any event, I think this is some data that raises some questions about federalism, because federalism isn't simply about stopping Congress from from voiding an act of Congress, but I think it also has to take into account state affirmative policy choices. Okay, so with that one qualification, I think what I want to conclude with is kind of an assessment, and I think it will be interesting to compare Justice Rehnquist to Justice Roberts the more we get experience with Justice Roberts. The comparison is interesting because perhaps those two justices, if you were to look at their political connections and political commitments, there might be a lot of similarity. But as a matter of constitutional doctrine and as Chief Justices, in my opinion, the early returns show comparing the two on a matter of constitutional principle and doctrinal consistency, I think Justice Rehnquist fares very well. Justice Roberts, in my view, seems interested in politics and policy. He seems very interested in the results of cases. In comparison, Justice Rehnquist, I think, seems to have been far more concerned with constitutional principle, that he was more willing to embrace results of particular cases that he might not have preferred as a legislator, but felt that institutional and constitutional principles dictated that he not follow his personal beliefs. And I do think that his record shows that he was really a believer in the principle of deference to legislatures on economic matters and was not sort of an opportunistic justice. And I think that, that I would say preliminary assessment, my guess is that that's going to become the more dominant view of Chief Justice Rehnquist and the Rehnquist court the further we get from it in time. Thank you.
Well, thank you very much, all of our distinguished panelists. And we have just a few minutes left in our assigned time to, I hope, have some dialogue here with the members of the audience. But before I get to the audience, I would like to give the panelists a chance, particularly perhaps Professor Berger, it now being longer since you had your say, to react to some of the comments that other panelists have made, if any of you care to do so. Professor Berger.
I have things to say, but I'd like to hear from the audience,
okay,
so I'm going to pass.
Very well. Professor Berger?
Same.
All right. And you've had your chance.
I agree.
Professor Schwartz, very well. I see a hand in the back of the room. Thank you.
University of Michigan. I guess this is addressed to Eric Berger primarily. There's some appeal to the Gregory V Ashcroft approach, just in the sense that if what Congress is doing is very unusual, it's stepping close to a constitutional line, it's raising constitutional concerns, that rather than either saying it's unconstitutional or not, binary yes, no, that the court takes a more modulated view and say, well, okay, we'll let it go, maybe, but you've got to be really clear about it. You're going to push this that close to the line. And the thing is, without regard to the substance of a particular case. Although I think what Congress allegedly did in that case, fixing the retirement ages for judges, is pretty unusual.
So I agree with most of what you said, I think up until the end, which is that I think the court can do all of that, but do it through a more modest presumption than a super clear statement rule. So for instance, the court could have come out the exact same way and said, well, we're not exactly sure what Congress meant by saying when it said that appointees on the policy-making level are exempted, but it seems that judges, they are appointed and they are sort of at a level similar to people who make policy, and given that this would intrude substantially on the state's prerogative to appoint their own people, we will have a presumption that we will read ambiguous language in favor of the state in these kinds of cases. That strikes me as a better way of resolving that kind of case, coming to the exact same outcome, than saying we are going to put on Congress the onus of specifically exempting each kind of employee who it wants to exempt, because of course Congress isn't going to think in advance, or it's unlikely Congress will think in advance of every possible case that will come up. So in general, I agree with your point, but my main critique of the case is not the outcome. It's not giving the states the benefit of the doubt in an instance like this, but is rather doing so through this super strong clear statement rule, because A, it seems unrealistic to expect that from Congress. B, it changes the kind of rules of the game for statutory interpretation. As I said in the talk, it really changes what had been a presumption into something much stronger than that. And C, and this was sort of my major takeaway, is I think it renders statutory interpretation in general more unpredictable, because then you have these canons, but they can be applied very differently in different cases. And we certainly see that with the constitutional avoidance canon, which is articulated so many different ways in different cases that it can really yield different outcomes. I don't know if you find that convincing, but that's...
Any comments from our other panelists? Look, I hope I wouldn't overstep my bounds as a moderator here to just key off of a couple of those points. And I think this may provide an insight into Justice Rehnquist's thinking. It certainly does into mine anyway. And that is, it was controversial, and I think it's still controversial, the whole notion of an implied preemption, implied congressional preemption in an area that, in the absence of congressional enactment, is clearly within the sovereign powers of the state, such as deciding how much you're going to pay your own judges or your own employees. And I think, and there is a body of thought that favors the whole notion that not only should there be a clear statement rule, there should be an explicit statement. There can be no implied preemption, because it is, an act. Perhaps even it goes too far to say it's an act of violence to the state's sovereignty whenever its ability to make decisions in those areas of state authority has been eliminated from them. It's certainly an act of encroachment, and to insist that the Congress say that it intends to preempt doesn't seem to me, anyway, to be too great a requirement when you're looking to Congress and whether Congress has actually taken that extraordinary exercise of its powers. So whatever that's worth to you from your moderator. Yes, sir, back there. Oh, yes, sure.
Morning. Mr. Robertson, Arizona.
Yeah, mic is on its way to you.
I thought I'd get rid of the unimportant part. First, I'd love to hear all the other panelists comment on Professor Schwartz's data that suggests that the Federalists weren't really Federalists. I think that's extremely provocative, and it's hard data for what it's worth, and so I'd love to get everyone, the experts' reaction to that. A more particular point is about the Raich case and the idea that Justice Rehnquist didn't want to turn back the clock and overrule, say, Wickard, but nonetheless found himself in the minority on the Raich case, which is a pretty hard one to distinguish from Wickard. And so I wonder if that we see him either sort of free riding as taking advantage of a chance to dissent when he knows the case will turn out the way it needs to anyway, or if we're seeing a libertarian streak that's really not about federalism so much, it's about the individual rights to access, in that case, what was purportedly a medical treatment. So a couple themes to comment on, please.
Let's take a swing at that.
I agree. Data, it's great to have facts. They slow us down. They're sometimes inconvenient, but I think the facts are terrifically interesting. I guess what I would have to say is that I think the preemption area is fundamentally different, and I don't know that to the extent the so-called States' Rights Five were concerned about protecting state autonomy, that there's anything inherently problematic for some of them, at least, about many of those particular decisions. I think it depends. I'm not sure we can generalize as readily in the preemption area, perhaps. So that's sort of all I can contribute to that particular discussion without having sort of parsed, as he's wonderfully done, all that data and looked at the individual cases. So sorry not to be more helpful.
I guess I'll just add briefly to that. I think that data is also very helpful, and I suppose the takeaway I would make, which is almost so obvious as to be banal, is, I think constitutional and legal norms matter, but so does the context of the case. And when I saw David's data, it reminded me of some pieces I've seen about Chevron deference, showing that the justices split a lot as to whether or not to defer to an agency in a particular case based on the particular regulation, and whether it's, these pieces code them as liberal or conservative, or pro-regulation or anti-regulation. And perhaps unsurprisingly, the justices often approach those questions of deference, which I suppose are, maybe similar to the preemption issue a little bit, often based on the context, which again shows that, context and the underlying dispute matter.
Yeah, I'll just add one more thing. A key difference about the preemption cases as compared to the sovereignty cases and the Commerce Clause cases is Congress can fix it. Right? The court in a preemption case hands down a ruling, but Congress can now itself respond. There's no place to go once the Supreme Court interprets a provision of the Constitution. They're the end of the line. And so I think that may have two effects. It may cause the justices to view those cases with greater fluidity, almost perhaps being interested to viewing their role almost as a conversationalist with the other branches of government as opposed to the end of the road. But I just toss that out as one difference that I at least see.
If the expectation is that Congress will fix an overly nationalistic preemption decision by the Supreme Court in order to protect state autonomy, to say, oh, we didn't mean to preempt, then we're saying, oh, well, Congress is safeguarding federalism, which is Garcia, which is the principle that Justice Rehnquist dissented from. I think the best explanation is, the justices agree, oftentimes they're unanimous or close to unanimous on preemption cases. The spread was, let's say, the mean of the Federalism 5 was, voting about 70% of the time to preempt, and on the liberal, nationalist wing, 30% of the time. So the spread is about, 40% of the preemption cases. I'm guessing that the difference maker in those cases has to do with a regulatory versus a deregulatory bias, and that the deregulatory bias probably accounts for a lot of the Federalism 5's pro-preemption votes. And I think that idea is becoming much clearer in the Roberts Court, because if you look at some of their recent decisions on structure, both federalism and separation of powers, what they're now saying, and Justice Kennedy, I think, is a leader on this, what they're now saying is we want to structural provisions are intended by the framers to promote liberty. And so we're going to construe them in a way that promotes liberty. And the unstated premise is, and by the way, liberty means freedom from regulation. And so I think that's kind of where some of the justices were coming from in the Rehnquist Court era on preemption decisions, and I think they're moving in a they're doing that more explicitly now.
And if I could just footnote one of those comments, the notion that Congress would step forward to protect the sovereign prerogatives of the states, which was at the core of the Garcia case, as you say, is ludicrous on its face. In fact, I think it was Bill Van Alstyne who said and wrote it must have been a lighthearted joke tossed off by Justice Blackmun in his opinion. But that was the key of Garcia. It wasn't whether or not core state functions was going to survive as a illimitable constitutional minimum, so much as it was, is this court going to continue to be, or going to become, I guess, because it hadn't been in 60 years, except for National League of Cities, was going to become truly the policeman on the border of state-federal boundaries. And that was what was overruled, as Rehnquist predicted in Garcia. That was overruled quite clearly in Lopez, where they did stand on that border, and they did police it, and they did invalidate a Commerce Clause measure that had no connection to economics, as you pointed out, Professor Berger. But yes, sir, please, we've got time for just maybe one more.
Because they are not all equal. For example, if those 5 Federalists, they preempted Obamacare, it would be equal to 20, 30 cases over there. Yeah, therefore, I think cases are not the same.
You can't just stack one up as though it's equal to the other. Thank you. Another question here, and this will have to be our last question, being advised.
First, Chuck, I'd like to hear your thoughts on David's slide, given the important role that you saw the presumption against preemption is playing in the Chief's thinking about federalism. And Lynn, I'm wondering, I think you make a very convincing case that Chief Justice Rehnquist throughout his career remained committed, strongly committed, to the notion of protecting traditional spheres of state sovereignty. But I'm wondering if you have any thoughts about why the doctrinal test of National League of Cities never comes back, and neither he nor any other justice makes a serious attempt to bring that test back in subsequent cases.
Why don't you start?
I think it's a terrific question. I think it may have to do with a couple of things. One is you need 5 votes, and maybe just as a pragmatic potential response. But I think it may also have something to do with the institutional stability concerns that have been raised, that if you can achieve the same end without having it look like, you know, some sort of we get ours back, and it may also be longer lasting. It's not clear that if you really want this to survive that you necessarily want to, you know, advertise aggressively what exactly you're doing. And so I think those are 2 very preliminary responses.
And with your specific question addressed to me, gosh, we're just out of time here. Actually, to be honest with you, I was surprised to see those statistics, to be frank. And they are very welcome. I'm looking forward to studying into that. I do think, though, and Professor Schwartz made, as part of his presentation, the Reno against Condon case. And I think that it may be in part instructive anyway. That was one in which, as we learned, I guess it was South Carolina that had was distributing and selling its database on driver's license personal data, and the court simply looked at that as an article of commerce. It was an article of commerce, and if anything is within Congress's power to regulate, it is those things that are in interstate commerce. Ultimately, that was the result obtained after Lopez struck down the gun-free school zones statute. Congress has now re-regulated. It has regulated the article of commerce itself, guns. So the only significance of Lopez wasn't its result. It was its doctrinal significance. But I think that may explain at least some of the cases up there, but I'm not even sure about that, to be honest. But thank you very much to our panel here. There's excellent discussion, and we will turn it over to Sally.
It's fun. Yeah, it's good to meet you. Likewise. Great job, Chuck. Really good.
Thank you very much. We're going to take a 15-minute break.